Well, hello, everyone. This is Charles Namey. I'm a real estate broker here in Austin, and I'm part of a small group of realtors and brokers, and one of our agents is an attorney too. And we meet every week and chat every Tuesday morning about 11 o'clock. Takes about an hour. We talk about we talk real estate and some other issues too. But we talk about what we face, our successes, our challenges, and we discuss and try to find solutions for the challenges. And today we have Ms. Deborah Sonnesheins, and she's part of our group. She's an excellent realtor and a brilliant attorney. And she's not practicing law, I don't think, but she can help us wiggle through some of these legal questions that she can help direct us which way to go. And with that, I'm going to introduce Deborah Sonnesheins. She's making a presentation about new construction and contract with builders. Thank you, Deborah, and I'm going to turn that over to you.
Well, thank you, Charles. That was a nice introduction. With our group that we have here, we like to try to present information that we've done and experienced in the past. And this is part of a workshop that I do for first-time home buyers. And this is obviously not legal advice. It's just information that's provided to first-time home buyers because many of them don't have a clue what they're getting into when they are looking for new construction. And of course, everybody wants a brand new house. So let's talk about that. Okay, first of all, I just want to remind you that this covers only brand new constructions, not resales of new construction. This is for a first-time owner of a new house that's constructed. It does not cover, it's only for single family houses. It's not for manufactured houses, and it's not for construction that includes both land and building. The scenario where a person says, I want to build my dream house, I'm going to go hire an architect and I'm going to go buy some land. This is usually the kind of contract discussions you have when you are buying a house that is in a subdivision. Okay, so let's get started. Most builders call these the earnest money contract, and this is usually entered into at the time you go talk to a builder and you're sitting there in their model home that they have in a subdivision, and you decide, you've been investigating a plan, you've discussed the part of Austin you want to own your house and the type of construction. So this is and you've discussed things like financing with them or purchase money. And usually people ask in advance, well, how long before my house might be built? So those are kind of discussions that you've already had, and it's time for you to sit down and look at a contract. So that's what we're discussing today, is a sample contract. Many of the items that we'll be discussing here are parts of contracts I've seen with many builders, but I just want to warn you that there are some things that are different, but the major things that I'll hit on in our time left is the major things. So the first one that I have it highlighted here on the screen, the things that I think are really important. The first one, of course, is closing date. And most of these contracts will state that the closing date is determined by the seller, who is the builder. So that's this number one item that I have using my pointer. So that's probably one of the things that shocks most people, whether they're experienced or first-time home buyers, is that they don't get to select the closing date. And a lot of people will say, oh, that's all right, I'm going to be following up. I'll drive past my lot at least once a week to check on it, to see how the construction is coming along. But believe me, most people are surprised when they get the call from the representative of the builder and say, we're ready to close in 2 weeks. We're getting the CO from the city on next Friday, and then we'll be ready to go. Okay. The next item I pointed out here in this contract, and this is a 14-page contract, so obviously I won't be covering everything, just hitting the highlights, is the purchase price is valid provided it's paid entirely in cash, which, as you know, even though you might have financing at closing, at any closing, whether it's new construction or not, the seller gets cash at that closing, unless it's one of those types of transactions where the seller is doing the financing. Okay, or another item that's really popular now, and maybe we can have a discussion on that, Charles, at some point, is rent to own. That's another area that's becoming so popular now because first-time home buyers and a lot of buyers are not able to qualify for a loan. And also it will include any premiums. Now with new developments, there are lot premiums, you know, for green belts or corner lots, or there's just usually premiums. When you see the discussion of how much the total price is of the building, the house, and then how much you're paying for the land, quite often there's a lot premium. So that's, make sure you understand, your client can understand that. Okay, I'm going down to another section, and it's their definition of what a cash sale is. And this whole section that I scrolled through, and I skipped because most of the people in the sales office for the builder will, first thing they'll tell you, and they usually have a flyer they'll hand you that states what kinds of benefits the builder's offering. And in many cases, they help you with closing costs, they help you with down payment assistance, they give you some money for the extras that you might want to add. So that's what this paragraph is. So that's pretty typical, and most buyers of new construction are used to that. So Charles, you and Wendell can stop me if I get to a point you think you'd like me to clarify a little more, or you have a question about, or even if you have a comment based on your own experiences. So please interrupt me. The next one discussion is a discussion of the plan, and most of their sections will say that you are buying a plan that belongs to the seller, and the plan might change, because remember, the builders are in business to sell properties. They're not in a business to most of them are pretty standard. Most of the plans are, and they change. They change from subdivision to subdivision, from year to year. They change in a lot of ways, and they want to let you know that the plan that you've selected might very well change. And I've had experience with a buyer who went to visit a friend who had just bought a new construction, and then went to that builder and said, I want that plan, and I would like that on this corner lot. And they signed a contract, but then a month later they received notice from the builder that that plan was no longer available. They were able to settle on something that was close, but that's an experience that I like to remind my buyers, that the plan could very well change. So don't fall in love too much with a specific plan. And the purchase price, I'm on 1.4 now. The amount is agreed to between seller and purchaser, and is not subject to change based on the appraisal through the mortgage process. As you know, when most of us do resales, and quite often we have to go back to the seller to try to negotiate some kind of concession if we find that the appraisal comes in low for a resale. We do that all the time. Most buyer representatives are pretty skilled at negotiating with the other agent and explaining the heartbreak of not being able to get financing. And usually if it's pretty close, you can do that pretty easily. But in this case, with these new construction, it's the seller is not going to budge just because your lender or their lender is not, it doesn't come in at appraised value. And of course, if you use the seller's lender, you know, this has already been discussed and agreed upon behind the scenes before you even start. This usually applies when you're not using the builder's lender. The next section, many of these new construction builders don't want investors. And in this particular case, in this contract, it was for 2 years. When you buy it, you have to say you're living in it, and that you will not rent this place out or become an agent for someone else to rent it out for 2 years. And a lot of people and you say, why does the builder care if you're going to live in it or if you're an investor? And the reason is because renters don't take care of the property the way sellers do. I know in my subdivision where I live, it's still being built out. I'd say it's about half built now. And the property manager regularly drives around and taking a look at people's landscaping, especially with the drought we're in. And a house that has been rented near where I am, I think they hadn't watered the lawn, and I don't know, since they've lived there. And so they recently went by with and brought along the landscaper who manages the common property, and they had a talk. And the other day I drove by there, and the landscaping is looking better than mine. So that's an important part of this contract, because the builders who are still trying to sell new properties want all the other properties to look good. And I'm sure any subdivision you drive around in where there's still construction, you'll be able to point to a street that is beautiful, meaning the builders put all their nice plans on that street, and they put in extra landscaping, and they put in extra, the streets sometimes even look a little wider and straighter. And the trees are beautiful too. So they like to make sure that that the subdivision shows well until it's been turned over to the residents. Okay, this is some more information about the closing, more detailed. It again states that it's up to the seller to decide on the closing date. And let's go down to the section on construction and improvements. There's this section I always like to point out to a buyer that I represent, is that most of the builders will have a feature sheet, and it's just an advertisement, and the builder is not constrained to offer those features either, not just the plan, but any features that they show you on their feature sheet. Now that feature sheet, which is important too, and it might be a subject of another presentation, usually explains what it is that you're getting inside of the house, and what the standard is, what you get for no extra cost, what the middle ground is, what you get for a little bit more, and then they also will have a premium. And if you've walked around in some of the houses that you go, wow, I can see why they got an extra $100,000 for this house, it's because there's a lot of extra features in there, either selected by the buyer or selected by the builder at the time they made it a spec house. And spec houses is another presentation also, how to buy a spec house. And the standards for construction, again, when you buy a new construction, obviously this paragraph talks about new home demonstration. That's kind of like your inspection to develop a punch list for the builder. And there's another section later that I'll concentrate on that. But the standards of construction, they always will refer you to the building standards, the building codes, and they always guarantee you that they're way, way above the building codes. That's what this section describes. And I just like to ask my buyers to, sorry about that. I always like to ask my buyers to read that, because they need to know what will and will not be part of it. And the new home demonstration and inspections, I want you to know that usually after the certificate of occupancy has been issued and the date for closing has been determined, they will ask you to have a new home demonstration. Quite often it's the agents who do this, who walk either with the client or even for the client to do that. And it's basically to put together a punch list. And usually what I like to do is I hand my clients a copy of the floor plan, and also a copy of that list of all of the features that they had agreed to. And between the two of those, we kind of divide up the responsibility. We check it because this new home demonstration will be over in about a half an hour. So we together have that in our hands as we walk through the house. It's actually a very good walkthrough. And also you can have inspectors on the premises to come inspect at certain points. There's 5 points that places during the construction that I always advise the clients to get an inspector. You can get the regular inspector, and I advise them to use an inspector that I use for resales because they know everything and they're usually very, very, very experienced. And the city inspects the houses, for their building permits at different intervals. And I think there's 5 points that here in Leander anyway, they will describe, and Leander and Round Rock also, I know they have 5 points that they come and inspect. So at that point, you have to stay on top of, when the building goes up, is to be available to do inspections. The builders tend not to like you to be there, underfoot when their inspections are going on. So I will usually schedule them for late afternoon because the builders, so you won't get in the way of the builders. They usually start by 8 o'clock in the morning and they're usually done around 3 or 4, depending on the schedule and how fast they're going. Okay, so the next section is on the landscaping. That's just general information about landscaping. But one is the seller will not replace the grass or the sod after closing. A lot of people think that's part of the warranty, but it's not. So I make sure they all understand that if you had a drought season like the one we're going through now, don't expect the builder to replace it. Now, I was fortunate in my case. We had a huge patch that we felt was that of sod that dried up, that we felt was due to the drainage. So the builder came back and replaced it. But usually they don't, because a drought is a drought. Drainage is really important because you'll have many, especially young people who have kids, who decide they want to buy a house and they plan to put in a swimming pool. It's really important that this contract, as well as the HOA documents, are very strict about you changing anything about your property. Yes, you own it, but if it affects the drainage on the property, it can be really severe. And a lot of people don't realize the impact that swimming pools have on the drainage on a lot, especially now when we have the subdivisions where the lots are getting as small as 1.15 of an acre, which is usually like a 40-foot lot. A lot of them are very small. You really shouldn't dig up half of the lot to put a swimming pool in. It's kind of common sense that you think that it'll affect it, but the subdivisions nowadays are bigger, really big. And in the summer, people want their kids to go splash around in the pool, and the subdivision pools are packed in the summer. So they say, oh, this is nuts, I'm going to put in a swimming pool. You say, well, what about the zoning and the inspections from the city? The cities usually wash their hands of that. And you say, well, what about the architectural committees who have to come and approve the pool? Well, they wash their hands of it. They make you sign all kinds of disclaimers that you cannot use the fact that zoning allows for a pool, or that the architecture committee allows for a pool, or anything else, spas, whatever you're putting in. You can't use that as a reason to defend yourself if there's some damage from the property not draining properly. And this, of course, this disclaimer in this section that I'm pointing to says you're releasing the seller, the builder, from if you do anything, if you change anything on the property, and sometimes it's just putting in another tree, it affects the drainage, which is so important here in middle of Texas. there's a disclaimer in most of these contracts that, hey, well, don't come talk to us if you have a problem. And here in Texas, there's a famous case that we always refer to when it comes to drainage is we call it the Weekly case. And that was a David Weekly case where the people went in and changed a whole lot of things to the property after they bought it from David Weekly. And it affected, you've probably seen some in your training classes when you got your licenses, that showed a case where a house was built and then the rain came so ferociously that it washed away a huge part of the lot, and then the house fell over. Now that was one of those cases from years ago because people changed their lots, and now the builders are forced to put in these kind of disclaimers. Okay, let's go down, talk and look at this section about market decisions. And the market decisions is just what most realtors understand, is that builders are participating in a home building business, and while they want to make all of their buyers happy, that there are certain constraints that they have, especially for many of these builders who are corporations and they owe a certain amount of profits to their stockholders. Many of them are, most of them are. Very few are family owned nowadays. Okay, let's see, this other section I think I make sure that my clients understand is the section on attics and garages. The attics are not necessarily something you can use for storage. Many of them, and it's up to you to decide to determine whether it can be used for storage. And I highlight here, the purchaser acknowledges that garage space may not be sufficient to accommodate, your vehicles. One of the issues also recently that have come up is electric vehicles and installing the charging stations. The builders will not guarantee that you can put a charging station in there. In the future, that may change. I think it probably will, because so many people will have electric vehicles that the charging stations have to be there. Right now, let's see, I had a client who they owned 3 electric vehicles, one for his spouse and one for himself, and the extra one for charging, because they had to use a charging station near their house for charging because they couldn't put it in their house. So obviously they had to have a standby. So they had 3 cars just because of the extra charging station. So that's an issue with the garages, and because people don't think about that at the time. You might be planning to get an F-150, after you buy the house, because your loan officer told you don't go out and buy anything. And then you find out your F-150 won't fit in the garage. Okay, let's move on. These are all pretty standard things here. Environmental conditions like mold and other issues associated with it after you bought the house. That's kind of common knowledge that most people think about even when they're buying resale property. And the energy costs, a lot of people nowadays are looking for green building, the LEEDs, declarations for a house. And usually the builders say, hey, we're not promising it. Now, there are some new condo construction projects in Austin and many of the cities that do tout that they are energy efficient. But it's easy to put energy efficient investments into a building project that is mostly 2-bedroom condos. That's pretty easy because you're all together there. Here's another one most people don't know, is that the builders release your information, pictures and such, for their marketing, mostly marketing, and for their stockholders. So your house may show up someplace, but it's hard sometimes to determine whether that's your house or your contract, because they are pretty much the same. And usually a builder sticks to a certain design, or at least 4 or 5 different designs in a certain subdivision. Deed restrictions. And this is, again, just a disclaimer to let you know that even if you don't read it, if you go back to the original documents that the builder filed when they started the project, If you look at the association documents, when they started the project, you'll find a lot of constraints that most people don't even think about. And believe it or not, here's a good one I like to point out to my clients. Most people don't know that you cannot have a pit bull in most of these subdivisions. And as I walk around my subdivision or drive around, I see tons of pit bulls. and if all you have to do is have one of the pit bulls attack someone, and you'll understand why these are important to read. And that they also, this one is a good one because a lot of people want to know, because you cannot see a lot of they don't share the information. The builders don't share that much information. But one of these is they don't guarantee that you can use it for any other purpose than a house. A lot of people have offices in their houses, in their homes, which there's no problem with having an office there. But if you need to build something so that the FedEx delivery guy or the Amazon delivery guy can make 5 or 6 deliveries to your house a day because you're running a business out of your house, don't blame the builder if that's not possible. That's what they mean. And of course, homeowner association, utilities, whether it's in a certified utility provider and public improvement district. Let's just touch on MUDs really quickly. People who move here from out of state don't quite understand the notion of the MUDs that we have, where the builders, the developer, not necessarily the builder, the developer doesn't want to pay for all of the improvements. And many of these new subdivisions are located in the extraterritorial jurisdictions, which means the city is not going to build the infrastructure. So if the developer doesn't build the infrastructure and pay for it and get their money back when they sell the lots to the builders, then the people buying the lots are going to have to pay for it via MUD. Most of these proposals for MUDs, when they're presented to the state of Texas water department, they say, oh, they're only for 30 years, but there's some MUDs that never go away. So that's usually in the disclosures that the buyers get when they talk to the people in the office. This is just general information about who can sign for things for you. They're making note that they understand that in many cases, people are buying houses sight unseen. Okay, this is one that's in most of the contracts that a lot of buyers don't realize is in here, that within 30 days prior to the closing date, that's after that closing date that the builder has decided on their own, you can't change the contract anymore. And they don't have to change it. If you decide you no longer want their refrigerator, you want to get your own refrigerator, they'll tell you, well, we're dropping off the refrigerator at your house. If you want to get another one, you get it after you close. And we're not giving you the money back. Now here's the default terminations. This is the first thing you go over. Certainly when you have a regular resale, most agents will go over default because the clients will say, well, what if I change my mind? Because that's the problem that has occurred with many of the buyers who were trying, in the heat of the market that we just went through, they wanted to put down several offers, and they want to know what happens if I put down several offers. Well, this is another one of those issues where you always have to go over what the default and termination is if you change your mind. This one, you only get, most of them, they keep half of your earnest money and half of the money that you've put down for any different improvements at the center where you pick your design elements. And but on the other hand, the seller can terminate the contract, and the only thing you can do is, all they have to do is give you your money back. And this is usually in this bold capitalized print because they want to make sure people read it, but most people don't read it anyway. They don't understand that the seller can terminate the contract. Now, there's some other information down here that kind of amplifies it a little bit. And they can negotiate how they terminate it, but it's at their own discretion, meaning they can, if you terminate the contract and then you come back and say, oh, I didn't find another house, so can I have that house back again? And they say, okay, yeah, sure, it's still on the market, but we have the right, we don't have to give it to you at the same price or the same earnest money, or our lender doesn't have to give it to you on the same terms. So that this is important to understand, that essentially the seller, the builder, has a lot of power under these contracts. And if they at any time decide they don't want to do what they decide that you have done, especially at certain points, usually it's 30 days before closing, they can keep your money. That's essentially what it is. Now, this paragraph D, most of the contracts have this in here too, where it says if we have a disagreement about anything, it could be where you claim we promised that we would put crown molding in throughout the house, and I have a change order here, and you decide you don't want to put crown molding in, and we have a disagreement about it, and I say, well, I'm not going to close if you don't put crown molding in. And they say, well, we're not going to put crown molding in. This paragraph covers that. They say if there's an impasse, then the seller is the one who makes the decision as to whether you go forward at their sole discretion. And then these sections are on the warranties. And the thing that I point out, because different builders have different warranties, I point out here that in every state, and especially in Texas, because there's been so many lawsuits about new construction, is that in law, there's an implied warranty of habitability, which whatever you have in this contract, you cannot go under or less than. But here, this disclaimer says that if you sign this contract, you don't even have implied warranties. You have to defer to our warranty. And if you just look at the rules about new construction in Texas or any other state, you have to have a 1-year warranty. That's the minimum. Many of the builders have more than a 1-year warranty, and most of them will have a 10-year warranty on structural things. But just remember, it's the seller decides what is the warranty, not necessarily the government. And that's the purchaser and seller acknowledge that implied warranty habitability lasts for 10 years from the substantial completion of the home. And that means after 10 years, whatever the condition of the home is, you can't blame the seller and the builder. Let's talk about, this is just a force majeure. That just means acts of God, weather, wars, any other, if something else out of the control of the builder, the seller, happens and they can't satisfy their contract, you can't blame them. But this doesn't apply to the buyer. The documentation is proprietary, and you don't have, here's a good one. You cannot get copies of the architectural plans. Now, why is that important? Yes, sometimes people want to add things to their house, or they want to tear down a wall, or they want to change their garage into a living space. It would be nice to have had copies of your plans, so you don't have to go now hire another architect to submit plans to the city. And there's no specific performance like you see in the regular resale contracts. No specific performance. The dispute that if it becomes an issue, they can at close. Okay, if there's a dispute and the seller loses the dispute, the seller's offer is a refund of the purchase price. You can't get anything more, like pain or suffering or consequential damages that, because I didn't get my house when I was supposed to, and you wronged me, now you have to pay for my costs, extra costs, because I had to go buy another house. And none of that applies here. And it just says it survives closing. So if something happens after closing, after you bought the house, and it pertains to any of these other items up here, then it survives the closing. And and I make sure that people know, because quite often, everybody will eventually represent a lawyer in their purchase. You have to go to dispute resolution, not directly to court. If you have a beef with your builder, you have to go to alternative dispute resolution. Let's see. And it's if the arbitration results in an agreement that you should go to court because the arbitrator didn't understand the technicalities enough, then they say they don't want you to go before a jury. That's part of the agreement. And I don't know why they think they should tell you what kind of court case you can bring, but that's the way it is. Okay, that's it. Those are the highlights, but I think it's important for any person who's interested in building and buying new construction from a builder to look at the contract. Oh, and by the way, most builders will not let you look at a contract until you've come to what we call a meeting of the minds, meaning you're sitting down at a desk, you're getting ready to write out a check for earnest money, you're making appointments with the design center, you're picking the exterior colors, and at that point you get to see what this contract is and read through it, usually not before.
Thank you, Deborah. That's an excellent presentation. I've learned a lot more with this presentation. I appreciate that very much. Thank you. And the one thing I wanted to share was a document.
Yeah, thank you so much, Deborah. Very helpful.
Okay, let me see here. Share screen. Okay. And this is what I saw in my clients. In fact, we're closing in about a week and a half. And he wanted to make some changes. And this paragraph says it all. It says here, closing date. The closing of the transaction contemplated by this agreement is referred to any, so on and so forth. But this thing threw me off. Notwithstanding, I did not know the exact meaning of the word. But the meaning is that in spite of, the seller may direct the title company to schedule closing and the closing date. And that was something that my client wanted to try to, let me see here, wanted to try to, excuse me. Okay, my client wanted to change the date of closing and we just were not able to do that. Thank you, Deborah. I appreciate the presentation. It's excellent.
You're welcome.
Thank you for being on our team. And thank you for contributing and even helping me out the last time with this particular issue.
You're welcome. Happy to help. You guys are very helpful to me usually as well. So happy to be a member of this team.
Thank you, guys. And with that, we are going to close the discussion. And we will talk to you guys later. You take care.
Take care, everybody.